Hello and welcome everyone to our session on national treatment. This somewhat complements earlier sessions on the most favored nation principle. What do I mean by that? In general, as we laid out earlier, discrimination between different trading partners, between different products, different services, different service suppliers is prohibited. That means, on the one hand, that no WTO member shall discriminate between its trading partners, and on the other hand, it shall also not discriminate between its own products, so products manufactured, produced on its own territory by its, you could say, own producers, and foreign products or foreign service suppliers. And this is what we call the national treatment obligation or the national treatment principle, which can be defined as the principle of giving others the same treatment as one's own nationals, or as an extended version, one's own products, one's own service suppliers. And this is, as I already said, the other side to the non-discrimination coin, this highly valuable coin we have in international trade law. So let's get started with the details. First things first. In general, it means that any foreign person, legal entity, product or right must be treated by the respective regulating state, i.e. the one state where the product, where the person, or where the right becomes relevant, where it operates, where it is being exported to. And this treatment has to be similar to the treatment accorded to domestic equivalents or the national equivalent. So any foreign national has to be treated just like a domestic one, like the national of your own state. Any foreign product has to be treated like the domestic one, i.e. the product manufactured, produced within a state's own border, and any right held by foreign nationals shall be respected similar like the rights held by the own nationals. What does that mean? The national treatment becomes, however, a bit more specifically in the area of international trade law. It's applicable on goods that have lawfully crossed the border, and only on goods that have lawfully crossed the border, i.e. they were cleared by the customs authorities or by any other state agency that is endowed with the competence to control the entry of goods and persons. However, once you've lawfully crossed the border, you have a right to be treated similarly with your local competitors, be they service suppliers or products. So, in a general sense, WTO members are obliged to provide equality of competitive conditions for imported products in relation to their domestic counterparts. What is the overarching aim here? You have to, and I quote the WTO's predecessor, the GATT, in the case United States Taxes on Petroleum and Certain Imported Substances from 1987, you try to protect, or the national treatment tries to protect the, and I quote, expectations of the contracting parties, i.e. the members to the GATT, as to the competitive relationship between their products and those of the other contracting parties. Long story short, once again, we're being thrown back to the basics. You want an even playing field. You want all of the competitors, be they domestic or foreigners, to be able to compete and to have fairness in their competition. No special favors, neither between different trading partners, MFN, nor being granted to your own producers or your own products. Whether we find the national treatment obligation, 3 articles are particularly relevant here. GATT Article III requires that imports have to be treated no less favorably than the same or similar domestically produced goods, as we said already, once they have passed customs, once they have legally entered and in a sound legal fashion entered the borders the market of a given country. And the GATTs in the Agreement on Trade and Services, you have Article 17 that lays out the national treatment obligation in respect to services. And speaking of rights, we mentioned it earlier, TRIPS, trade-related intellectual property rights, the treatment on intellectual property, the most important or the most fundamental one, concluded in the Uruguay round when intellectual property rights became more and more important, assures that also there's a national treatment obligation in connection with intellectual property protection. Good. Starting with the most fundamental of these rules, the GATT. Because, as we said at an earlier occasion as well, trade in goods, trade concerning goods is the most vital one, the most developed one, the most far-reaching one. In services, there is some more room for discrimination. We'll come back to that at a later stage. For the time being, however, remember GATT Article 3 and the GATT in general. This is the most refined set of rules applicable in connection with international trade, and here in particular the rules concerning international trade in goods. We are far closer to genuine free trade when it comes to products than genuine free trade when it comes to services. And our starting point here is GATT Article 3. So what does GATT Article 3 tell us? Long story short, I won't read out the whole article for you, but it says this is a proclamation that no internal taxes or laws or regulations, so basically everything that may have an impact or that does have an impact on international trade shall not be applied to imported or domestic products so as to afford protection to domestic production. In other words, this says no protectionism whatsoever. Again, if your local products shall have an advantage, this should be an advantage owed to be better quality or better prices, more efficiency when it comes to the production and manufacture of products, but not because special favors, so lower taxes, for example, are imposed on domestic products, or any laws or regulations are favoring domestic products. Again, even playing field. You want just and fair competition here. But at the same time, when reading GATT Article 3, paragraph 1, this is non-operative by itself. If you look at the mere wording, you'll see the contracting parties, i.e. the states parties, the members to the General Agreement on Tariffs and Trade, recognize that, for example, internal taxes and all other measures having an impact on domestic sale, that they should not be applied so as to afford protection. They do not, however, clearly outlaw or prohibit such measures, at least not in the first article. So the first article can be seen by itself as sort of a proclamation or a quasi-preamble to GATT Article 3. But it is not entirely irrelevant, but you'll hear why in a few minutes. The second paragraph then, this is the operative one. So in other words, the first one is introducing the general obligations in GATT Article 3 concerning national treatment. The second paragraph then sets out the actual obligations. What you see here, this is the one dealing with taxation. So, no internal taxes or other internal charges of any kind shall be applied to like domestic products in excess of those applied, or there shall be no excess when comparing domestic products with foreign products. In other words, again here, if two products are like products, and we've already heard about the definition of like products when we talked about the most favored nation obligation. However, here it's a bit different, but no need to go into detail at this point. All you need to remember, if there are two like products, one foreign, one domestic, the exact same tax should be applied. So if you impose, let's say, a 10% tax on foreign beer, you have to impose a 10% tax on domestic beer. If you only impose, let's say, a 7% on the tax on domestic beer, that amounts to protectionism if you want it or not, and therefore violates GATT Article 3. However, this is not the end of the story. It becomes even a bit more complicated. If you see brackets like these, the ones saying sentence 1, sentence 2, that always means someone else added that. That's not part of the original provision. The original provision does not differentiate or speak of sentence 1 and sentence 2. This has been introduced by WTO jurisprudence in connection with realizing, or after the WTO realized, also the GATT members realized, wait, there are two distinct obligations. The first one concerns like domestic products, sentence 1. The other one, sentence 2, however, and sets out an additional obligation. Additional, why? Because you already see it at the very beginning of sentence 2, moreover, in addition, furthermore, you name it. No contracting party shall otherwise apply internal taxes or other internal charges to imported or domestic products in a manner contrary to the principles set forth in paragraph 1. So, this might be confusing for some because I just said that paragraph 1 of GATT Article 3 is not operative, or at least itself not obligatory. Because if you look back at it, the very wording says that the parties to the GATT recognize that internal taxes or any other charges having an impact on the sale of products or purchase, transportation, and so on and so forth, that they should not be applied. But they do not say that they shall not be applied, or the contracting parties oblige themselves or consider themselves bound or whatever. No, they simply recognize that they shouldn't happen. That sounds like a moral obligation. So GATT Article 3, paragraph 1 itself, because of its very wording, is not operative, not if it stands alone. However, it is not being left alone. It is supplemented, or you could say it has to be read in conjunction with GATT Article 3, sentence 2 of paragraph 2. And I know it might seem a bit complex already, but hopefully, at least after today's session, that will be understandable a bit easier. So, it is complemented by GATT Article 3, sentence 2 of paragraph 2, which then says no violation of the principles set forth in paragraph 1. So, taking this detour, that means that it does become binding indirectly by virtue of GATT Article 3, paragraph 2, sentence 2. But I'll speak about it over and over again because I remember back when I studied at first, it was very confusing for me. It took me quite some time to understand the impact of GATT Article 3 and the interplay of paragraph 1 with paragraph 2, and then you even add paragraph 4 to the mix, which we'll do at a much later stage, and then you end up all confused. But that does not necessarily have to be the case. Remember for now, GATT Article 3, paragraph 1, not obligatory. GATT Article 3, paragraph 2, both the first and the second sentences are obviously obligatory, and the second sentence refers to the first paragraph and thereby makes it indirectly but still binding. And now I'll add even a bit more to the confusion you might already have. Why? Because there is even an interpretive note add, Article 3 from Annex 1 to paragraph 2. Long story short, again, I'm using this phrase a lot, I know, but this is necessary because all of these technical cross-referencing here has to be summarized, and that's what I try to do here. So, again, sentence 2 simply says, okay, there shall be no violation in other cases, i.e. if not like domestic products or like products are concerned, but however, a different category of products. But that different category is not defined or laid out in sentence 2 of GATT Article 3, paragraph 2. No, that's where I need to interpretive note add. Why? Because this interpretive note add further explains, okay, there might be some misunderstandings. You know what? We'll clarify it here. And this note add includes or adds a new category of products or of product categories, i.e. directly competitive or substitutable products, and then as a follow-up, which are not similarly taxed in comparison with their counterparts that were produced domestically. So, and this now explains that in GATT Article 3, paragraph 2, we have two different categories. The first one is likeness. This means more or less 100% similarity, but however, even if two products are not 100% or almost 100% similar, they could still be competitive. So, and there are countless examples from WTO jurisprudence or countless examples you could think of in a classroom. So in my classrooms in earlier sessions, we were talking about what about cars? Are all cars like products? Or what if you have a big SUV, for example, or if you have a Hummer and you compare it with, say, a Smart or a Mini? Is that still likeness? Yes, both of them have four wheels and a steering wheel and are considered as cars in a broad sense, but are they indeed 100% similar if you drive a Hummer or you drive one of these fancy city cruisers, you could say? Still likeness? Yes or no? And you could over and over again repeat this exercise with countless products, MacBook or laptop, different smartphones and non-smartphones, because at the end of the day you can use both of them to talk on the phone. I know today most phones are smartphones anyhow, but I grew up in this one distinct phase where you had the regular mobile phones and smartphones, and the rich kids or the kids that really wanted to have a smartphone or be early adopters, they already had their smartphones. Other kids like me, for example, we stuck with our regular phones, the old school ones. However, you could still make the argument maybe they're like products, because at the end of the day you can use both of them and call your friends or whoever else you need to call. And these are just two examples. There are countless more in WTO jurisprudence. Interestingly enough, a lot of it also deals with alcoholic beverages. So this is not because myself, for example, as a teacher, I'm particularly interested in alcohol, or the WTO is not particularly interested in alcohol. It's just that many of the most important cases in this connection dealt with different types of alcoholic beverages, and therefore also it was necessary to resolve the question whether, for example, vodka and shochu are like products or only directly competitive or substitutable products. Why? Because in these two sentences that we find in GATT Article 3, paragraph 2, we have these two different categories, and it does make a difference whether two products are like or only directly competitive or substitutable. And last but not least, as I said, to add a bit more to the confusion, but hopefully after this session and after all of the sessions on national treatment, all of this confusion will have magically disappeared. We have GATT Article 3, paragraph 4. And what we find here, paragraph 2 refers to taxes and internal charges, whereas paragraph 4 refers to laws, regulations, and any other requirement affecting the internal sale of product or offering for sale, purchase, transportation, distribution, or use of products. So, whereas with the first one, what about our 10% value added tax, and then only a 7% VAT on on domestic beer, that obviously guarantees a privilege or gives an advantage to domestic beer, unfair competition, protectionism, unlawful. Here, one example you could think of at this early stage would be, what if there is a law saying that foreign beer can only be sold in a remote area in supermarkets, or in no domestic supermarkets in the first place, only in designated liquor stores, whereas domestic beer can be bought everywhere. This would be a law that would clearly violate GATT Article 3, paragraph 4. So again, you see here, non-discrimination, national treatment refers both to taxes and any other laws you could think of that discriminate unfavorably against against foreign products. So, to sum up, GATT Article 3 is substructured in several paragraphs. The first one says what is the very purpose of the provision. Why does it exist? The second one then talks about taxes and then is further subdivided into like products and directly competitive or substitutable products. And the fourth one refers to all other regulations adopted by states, by governments, and also applied by the government, by civil servants, by the authorities. So non-tax measures, in other words. And this slide here tries to summarize the extent or the overall content of GATT Article 3. Paragraph 2 has two different comparison standards. The first sentence refers to like products. This is a narrower category. Here, protectionism does not count. In essence, it amounts to protectionism, but you don't have to prove that indeed protectionism is the very result of such a measure. At the same time, however, the main criterion here is the degree of substitutability. What does that mean? If it's a 100% or almost 100% similar product, say foreign vodka, domestic vodka, Russian vodka, Polish vodka, or any other countries known for producing high quality vodka products, then it shall not matter whether it's a Russian one or a Polish one. Sentence 2, however, of GATT Article 3, paragraph 2, indeed refers to protectionism. Why? Because it then makes further reference to GATT Article 3, paragraph 1 and the so as to afford protection formula, commonly abbreviated as SATAP. Remember, in international law in general and international trade law in particular, we love abbreviations. And this is one of the abbreviations I like in particular because it's so technical and however describes, because you don't always want to say so as to afford protection, you simply say that's the SATAP test. And this one does not only refer to like products, but also to a broader category, namely the one directly competitive or substitutable products. In essence, that means that every like product is also directly competitive or substitutable, but not every directly competitive or substitutable product is also a like product. And this difference does play a role when it comes to the degree of discrimination that is lawful. If there are like products, two like products, no discrimination whatsoever. If they are only directly competitive or substitutable, some limited degree of discrimination is possible. So a slight difference in taxation is lawful here. Whereas when it comes to two like products, you have to apply the very, very same taxes on two like products, be one of them domestically manufactured, the other one was imported from a third country. And paragraph 4 then concerns the direct market relationship between goods. This category is a bit broader than Article 3, paragraph 2, sentence 2. The likeness here is, and this is now where it gets confusing, it is broader than likeness as it is mentioned in sentence 1, but not broader than the combined scope of both sentences in GATT Article 3, paragraph 2. Why not? Because, again, directly competitive or substitutable product is meant as a, you could say, fallback reference here, a fallback notion, which, however, cannot be found in GATT Article 3, paragraph 4, and that's why it is broader than the concept of likeness in the second paragraph, but not as broad as the notion of directly competitive or substitutable products. The one reference to likeness in paragraph 4, in other words, is somewhere between sentence 1 and sentence 2 of GATT Article 3, paragraph 2. So, as you could already see, and when we talk about the cases, this will become certainly a bit more accessible, but this is not the only way how you can regulate things. So if you look at NAFTA, for example, which includes a specific obligation, a specific provision concerning national treatment and national treatment obligation, says that here national treatment shall be accorded to the goods of another party of NAFTA, 3 countries, Canada, Mexico, and the US, in accordance with Article 3 of the GATT, including its interpretative notes. And again here also a further definition of what that means. That shall mean, with respect to a state or province, treatment no less favorable than the most favorable treatment accorded by such state or province to any like directly competitive or substitutable goods. So all of these categories are being mentioned in NAFTA as well, but at the same time, however, you see the differentiation is there is not so much emphasis on the differentiation here in NAFTA. Or to name another example, CETA, the Comprehensive Economic Trade Agreement between the European Union and Canada, also in Article 2.3, contains a provisional national treatment. And again here, Article 3 of the GATT is incorporated into and made part of CETA. What does that mean? Incorporating, from Latin, you'd say, okay, this, we take the article from one treaty and add it to another treaty. You don't eliminate it in the original treaty, you simply say, okay, we don't want to invent the wheel a second time, so what do? We take the very same wheel or the very same instruction or the very same manual and simply say, okay, we'll use this one and make it part of our treaty as well. Or in other words, you press Command copy and then Command V and in other words, to copy paste the very same provision into the new article. And here again, as we already saw in connection with NAFTA, a further definition of what paragraph 1 means. Again here, to a government in Canada other than at the federal level, or a government of or in a member state of the European Union. So again here, the internal constituency, both in Canada and the European Union, is taken into account here, because obviously enough, whereas the European Union is strictly speaking a trade party here, you still need the member states of the European Union to apply and respect this provision. And what does that mean? What do they have to do? They have to accord treatment no less favorable than that accorded by that government to like directly competitive or substitutable goods of Canada or the respective member states of the European Union. So again here, the difference between these different products, there's not so much emphasis in CETA as we could see and as we have already seen in Article 3 of the GATT. So, as you've already heard, what is the very essence of this treaty obligation? It means you want to protect the predictability needed to plan future trade. In other words, if you think about exporting to another country, you'd say, okay, what is the domestic equivalent to our product? Say you're BMW and you want to import your cars to the US, and then you look at, okay, there is already, say, a domestically manufactured car by Chrysler perhaps, and you simply look at, okay, to what level is it being taxed? And then you'd say, okay, we know already what the taxation scheme for cars like our cars looks like, so no surprises will be there. In other words, predictability is ensured. You don't have to be afraid that there will be an invention of a new tax regime to cover specifically your car, to name just one example. And that's, you can see it's an encompassing obligation, because actual and potential direct and indirect and de jure and de facto discriminatory measures all of them are covered by GATT Article 3, and all of them are prohibited by virtue of GATT Article 3. In other words, that's the very essence of this provision. You want to make sure that any country that is already trading with another country, that the pre-existing situation will remain as it is when it comes to domestic and foreign products, and at the same time you want to know what, if you somewhere in the future want to export your product to another country, you can see already, okay, what is the market situation like, how high are the taxes, what laws and regulations are applicable in connection with our products, and that is being guaranteed by GATT Article 3. And at the same time, as I already said, you somewhat freeze the status quo of competition and you even the playing field. How do you do that? By providing effective equality of opportunity for imported products. Why? Because virtually any measure that may already influences the competitive relationship between domestic products and legally imported foreign products is being covered by GATT Article 3. Once again, you want fair trade in the sense, not as most understand it, in the sense of workers' rights and labor conditions. That's another topic. In connection with national treatment, you simply want to say, okay, no unfair advantages given to domestic producers and domestic products over foreign ones. You want market forces to work here and not political forces. But speaking of politics and political forces, the main problem in this connection is that GATT Article 3 stands accused of being far-reaching and perhaps too far-reaching. Why? Because it covers a broad array of measures: internal taxes and charges, laws, regulations, and requirements affecting the sale, transportation, distribution, or use of products, and last but not least, the internal quantitative regulations, those requiring the mixture, processing, or use of products in specified amounts or proportions. So, in other words, standards that are necessary to fall under a specific tax category, for example. Or where you would say, okay, only up to a certain limit alcohol may be added to a certain beverage, whatever. Or everything that refers to the way a product is being manufactured to fall under a specific category is being addressed here. And because of this far-reaching impact of GATT Article 3, it stands accused of severely limiting the freedom of states to resort to certain measures, because it tells states, in other words, what type of tax regime they may apply, how and to what extent they may tax foreign products. It also tells states which laws and regulations they may adopt in connection with foreign products. And that's why it stands accused of curtailing and overreaching when it comes to restricting the regulatory autonomy, or to use an even more, or the one term you would associate with this notion, an even more problematic term, sovereignty, the big S word. Because politicians, governments are always keen on preserving their sovereignty without defining this term. Because one politician's sovereignty is another politician's protectionism, or from a WTO or a trade lawyer's perspective, protectionism. So again, on the one hand, you want to be protected against unfair regulations that offer an advantage to domestic producers and domestic products over your imported products, but at the same time, from a perspective of lawmakers, from a perspective of governments, from a perspective of politicians, they would say, well, we have some sovereignty here left. We didn't join the WTO so that some alien judges can tell us what we can and what we cannot do, or that we are not allowed to say America first, or European Union first, or Austria, Germany first. We have to buy local products, and therefore we'll also impose lower taxes on local products. But then again, you would say, as such a politician with this aim, and it's a reasonable aim, in particular from a politician's point of view, it might be, think of, for example, strengthening regional products and regional producers. But at the same time, the WTO would say, no, if people prefer regional products, that's fine, but they shouldn't prefer it simply because the price is artificially lowered or artificially increased because of higher taxes on foreign products. At the end of the day, consumer choices can be shaped by all sorts of factors, but they should not be shaped by governmental choices when it comes to taxation or any other laws and regulations. But this is somewhat the big, you could say, the big contrast, or the two big conflicting interests here. On the one hand, you want to protect foreign producers and foreign products from being discriminated against, and also that they want to know how the market situation looks like by merely looking at what does the market situation look like for domestic products. But at the same time, however, governments, politicians, policymakers of all sorts may be keen on preserving a state's sovereignty. And that's why in this connection it is necessary to look at, okay, what exactly does GATT Article 3 say? And that's why I want to emphasize it, and I've emphasized it over and over again, but one last time in this connection, it's all about the competitive position of foreign goods, or the competitive relationship they have on a given member states or WTO members market. Because here again, there is the risk that the national treatment obligation eventually becomes a tool to undo all sorts of legitimate domestic policy choices. So the big fear that if governments want to protect the health of their population, they want to protect the environment, and then WTO law, and we all know that, a politician comes up with a suggestion, and then some experts would say, well, that's against international law, that's against WTO law. We could lose a case at the WTO if we adopt this or that measure. So, long story short, however, is GATT Article 3 does not prevent states from adopting a certain measure to protect the health of their population, to protect the environment, or whatever other legitimate government policy choice you could think of. So if, for example, government says we want to prevent our population and the consumers in our country from drinking too much alcohol, and therefore will impose a high tax on alcohol. Think of countries like Norway, where alcohol is quite expensive because of the high taxes. However, why is it so expensive? Because Norway has said, okay, we're in a country in the north, it's cold, we do not want our people to become alcoholics, so we try to use our tax system to redirect consumer behavior into a certain direction, or to put pressure on our consumers that they abstain from drinking alcohol simply because it's quite expensive. That's why common saying says that, for example, Norwegians, when they're in other countries, they're always surprised by how cheap alcohol is because it's so expensive in their own country. That's a legitimate policy objective. It's also a legitimate policy objective to say, okay, there are higher taxes on cigarettes, or that you would ban advertisement for cigarettes. All of that is perfectly reasonable, and all of that is lawful. GATT Article 3 only tells you that if you impose high taxes on alcoholic beverages, these high taxes should be applicable in connection with all alcoholic beverages, regardless of whether it's foreign vodka, for example, or foreign beer, or whether it's Norwegian vodka. I don't know, honestly, whether such a thing exists, but for example, or Norwegian beer. It simply says you can impose, let's say, hypothetically speaking, a 50% value-added tax on alcoholic beverages. All that GATT Article 3 tells you is that you have to apply a 50% tax both on foreign and domestic products, and not say 50% tax on foreign beer and only 10% tax on domestic beer. Because here again, this would lead to protectionism and be thus unlawful, as the wording, as you can already find in the wording of GATT Article 3, paragraph 1. Same thing goes for banning cigarette advertisement. That's perfectly fine from a government perspective. But again here, banning only foreign cigarette suppliers, foreign cigarette manufacturers from advertisements, from making advertisements in sports, wherever, think of Formula 1. That, however, is not justified, because again here, if you want to ban cigarette advertisement, you have to ban it in total, because from a perspective of the likeness, or the probability that you will have lung cancer, from the perspective of the patient, it doesn't matter whether it was foreign cigarettes or domestic cigarettes that have caused or contributed to cancer being in your lungs. Long story short, all it says is no discrimination when it comes to taxation or domestic measures. But other than that, there are no restrictions on the policy or the freedom to adopt legitimate policy choices or pursue policy objectives. Having said that, that would conclude for the time being our preliminary session, national treatment. In the next one, we'll go into more detail concerning taxation and also domestic laws and regulations, both when it comes to services and products. Having said that, I wish you, depending on the time you're watching this video, you've watched this video, a good start in the day, a good remainder of the day, or a good night. Goodbye.